If you drive anywhere in America, February 2026 could quietly become one of the most expensive months you've ever had behind the wheel. Not because gas prices spike, not because your car payment changes, but because a new wave of driving rules is about to flip how the roads are policed in a way most people still don't see coming. These rules weren't debated in primetime hearings. There were no countdown graphics on the evening news. They moved quickly, mostly out of public view, and they were designed to do one thing extremely well: capture violations at scale. Technology will be watching, automated systems will be calculating, and the dollar amounts involved are not small. Starting in February 2026, 5 new enforcement rules will begin pulling money directly out of drivers' pockets, often without a single traffic stop. We're talking hundreds of dollars, thousands of dollars, and in some cases, rolling penalties that keep stacking until you fix the issue. The real danger isn't just the rules themselves, it's how abruptly they're being turned on, how quietly they were finalized, and how unprepared most drivers are right now. By the time many people realize what changed, the fines will already be active, the letters already mailed, and the damage already done. For months before any of this hit the public radar, there were warning signs. If you knew where to look, transportation analysts started noticing odd activity in Washington. Closed-door meetings, federal agencies quietly syncing up with tech companies in new ways, enforcement budgets being redirected into long-neglected departments. Even more telling, the usual pushback from automaker and insurance lobbyists went silent. And when transportation policy goes quiet in D.C., it usually means the major decisions have already been made. My name is Sophia, and I've spent years tracking how regulatory changes like this actually land on real people. Not on paper, but when the bills arrive. What made this moment different wasn't just that new driving rules were coming. It was how fast all the pieces moved into place at the same time. State DMVs started quietly updating their codes. Insurance companies rewrote their internal risk formulas. Law enforcement agencies began buying new monitoring hardware before most drivers had even heard there was anything to prepare for. This wasn't slow reform, it was staging. And preparation at that level only happens when enforcement is about to ramp up. The question was never whether new rules would arrive. It was how aggressive they would be, how much money they'd pull from drivers, and whether people would realize what was happening before February 2026 turned nice to comply into comply or pay, in practical terms. By early summer, the timing came into focus. February 2026 wasn't random. It was the point by which federal systems would be fully synced, state enforcement agencies would be operationally ready, and automated monitoring networks would be live nationwide. This is not a soft launch. It's not a small pilot. Internally, federal transportation officials have referred to it as an activation phase. That word matters. Activation means enforcement starts immediately, not after months of grace periods. By February 2026, every state will be lined up on the same baseline rules, the same verification systems, and the same penalty frameworks. Once that switch flips, there is no built-in cushion for confusion or "I didn't know." Officials have already said that within weeks of the start date, active monitoring will be running in all 50 states. Not just the occasional traffic stop, but continuous, tech-driven oversight that doesn't miss, doesn't get tired, and doesn't offer much discretion. What makes this especially alarming is how few drivers know what's coming. Recent surveys show fewer than 1 in 4 licensed drivers can correctly name even one of these new rules. That gap between how ready enforcement is and how little the public understands is exactly where serious financial harm happens. The systems don't slow down while people catch up. They just start issuing penalties. What also separates February 2026 from older changes is how the enforcement model itself has evolved. For decades, traffic law depended heavily on humans. An officer had to see the violation, decide it was worth acting on, and then make the stop. That naturally capped how many violations could practically be enforced. These new rules strip away most of that limitation. Enforcement no longer depends on how many officers are on patrol or where they're positioned. It's woven into infrastructure: cameras, sensors, databases, real-time verification, all doing work that used to require judgment calls. That shift changes everything. An insurance lapse that might have slipped by unnoticed for days will now trigger a fine instantly. Slowing down only when you see a camera no longer helps when your average speed is being calculated over miles. A quick glance at your phone that once depended on an officer's direct observation can now be captured by systems that never blink. That's why officials keep calling these rules transformative. They're not just raising fines, they're redefining how compliance is measured. And when compliance is measured continuously, almost everyone who isn't prepared is going to trip something. The financial stakes are huge. Experts estimate that drivers who don't adjust could be hit with anywhere from $500 to over $10,000 in penalties in the first year alone, depending on how many systems they trigger. Those numbers aren't guesses. They're already written into federal and state codes. This is the moment when driving in the U.S. shifts from casual compliance to constant accountability. The first people to feel that shift will be the ones who assumed nothing important had changed. The first rule targets something inside many cars that most drivers barely think about. Beginning in February 2026, compliance with event data recorder requirements becomes fully enforceable. If your vehicle was built after 2018, it's expected to have a working event data recorder, an EDR, in proper condition. This device is no longer treated as background tech. It's now an inspection item. If it's faulty, disconnected, or clearly tampered with, the penalty is automatic. The base fine starts at $750 before any knock-on effects are considered. What makes this rule so powerful is how it links enforcement and insurance. Event data recorders capture detailed information about what your car was doing just before an incident: speed, braking, throttle position, and more. Starting February 2026, insurers get expanded access to this data when handling claims and investigations. That means your driving behavior stops being a matter of opinion. It becomes documented. For years, most people assumed these devices were mainly for engineers and crash reconstruction. Now, they're part of the accountability system. They show exactly how you were driving and strip the gray area out of fault disputes. For anyone who has never checked whether their EDR is actually functioning, this rule creates a hidden risk. You won't find out there's an issue until an inspection, a crash claim, or a roadside check exposes it. And when it does, the fine arrives with it. This is where a lot of drivers realize that modern cars aren't just transportation anymore. They're evidence machines. The second rule is the one officials expect will generate the largest volume of violations the fastest: nationwide real-time insurance verification. In February 2026, this system goes fully live and completely changes how coverage is enforced. That plastic insurance card you hand over at a stop? Functionally obsolete. A national verification database will link law enforcement systems, toll gantries, and automated plate readers. Every scan pings your insurance status in real time. If your policy is inactive, even for a single day, the system flags it. There's no built-in warning. First offense, $1,000 fine. Second offense, additional financial penalties and mandatory license suspension. The trap is how common short lapses really are: missed payments, expired cards, billing glitches, switching carriers. These create gaps far more often than people realize. Under the old model, those gaps often went unnoticed unless you were pulled over at exactly the wrong time. Now, the system is checking constantly. It doesn't care why the lapse happened. It only cares whether coverage exists at that moment. Once the violation hits your record, clearing it is difficult. This is where many drivers get caught. Not because they deliberately chose to drive uninsured, but because they assumed a brief gap wouldn't matter. After February 2026, it matters immediately. If staying ahead of changes like this helps you avoid expensive surprises, make sure you're subscribed. The rules are shifting quickly, and missing a single detail can be costly. The third rule is the one safety advocates pushed hardest to accelerate. And it's also the one most drivers underestimate until it hits them: automated cell phone detection. In February 2026, this technology becomes fully enforceable. And it doesn't work the way most people think. These aren't just upgraded red light cameras. They're advanced systems placed at major intersections and along busy corridors that analyze driver posture, hand position, device location, and screen glow inside moving vehicles. They can tell the difference between a phone sitting untouched in a cup holder and a phone actively in use. They can read the body position associated with texting, scrolling, or holding a device near your face. And they run continuously. No officer judgment required. First violation, $500. Second, $1,000 plus a mandatory distracted driving course. Third, a 90-day license suspension. By the time rollout is complete, more than 300 metro areas will have these systems active, with plans to expand further. What makes this rule so punishing is how normalized phone use behind the wheel has become. Many drivers don't even classify quick glances as using their phone. Many assume they're only at risk if an officer happens to see them at the exact wrong moment. That assumption no longer applies. These systems don't give verbal warnings, they generate official notices. And once a violation is recorded, challenging it is difficult. The evidence is photographic or video-based, time-stamped, and stored. For drivers who rely on habit instead of intention, this rule alone can produce multiple tickets in a short span. It's not about how careful you feel you're being. It's about whether your behavior matches what the system is programmed to flag. The fourth rule rewrites something drivers have quietly relied on for decades. The idea that speed enforcement is about catching you at a single point in time. Starting in February 2026, average speed monitoring zones will be expanded across federal highways and major routes. Instead of clocking your speed at one spot, cameras record your entry time and exit time over a stretch of road. Your average speed for that entire segment is calculated automatically. If that average exceeds the posted limit, you get a violation. Slowing down when you see a camera won't save you if you've been over the limit for miles. This rule targets drivers who run just a little fast for long periods, not just those who spike their speed briefly. Fines start around $300 and can reach $800 when your average is more than 15 miles over the limit. From an enforcement standpoint, this is extremely efficient. It wipes out the old games. No more trying to guess where the officer is. No more quick slowdowns near known camera spots. The system doesn't care where you went fast or slow, it only cares about the math. And because the calculation happens after the fact, many people won't know they've violated the rule until the notice shows up in the mail. For commuters who cover long distances daily, this quietly increases their exposure to repeated fines. A habit that once felt minor suddenly becomes expensive. This is where a lot of drivers begin to see that enforcement is no longer reactive. It's analytical. And when enforcement is analytical, your consistency over time matters more than a single moment. The fifth rule is what locks the system together, and it carries the harshest long-term financial impact. Beginning in February 2026, emissions compliance won't be limited to scheduled tests or shop visits. New roadside emission sensors will run passively, reading vehicles as they pass. They can detect non-compliant exhaust in real time and compare it instantly to federal standards. If your car fails, a violation is generated automatically and mailed within 72 hours. The initial fine is $400, but that's only the beginning. Once flagged, your car enters a compliance window. You have 30 days to complete repairs and verify you're back in spec. Miss that deadline and daily penalties of $50 start stacking. They don't pause, they don't reset. After 90 days, your registration is automatically suspended. Your vehicle is no longer legal to drive, even if everything else from your license to your insurance is in order. This rule bites hardest because many drivers won't know they're out of compliance until that first letter arrives. Older cars, modified exhausts, and deferred maintenance all raise the odds of being flagged, and repairs to emission systems can easily run into the $2,000 range or more. What used to be an occasional headache now becomes a rolling financial threat. The longer you wait, the more expensive it gets. This rule isn't designed to gently encourage you to fix problems. It's designed to force repairs quickly, using money as leverage. And this is where the impact becomes uneven. Not everyone can absorb that kind of pressure the same way. Analysts and consumer advocates have been clear about who's most vulnerable. Lower-income drivers, families with older vehicles, and people whose jobs depend on daily driving. A newer car with modern emissions controls and stable insurance is far less likely to trigger multiple violations. An aging vehicle with overdue maintenance is far more exposed. The same logic applies to insurance. Households living paycheck to paycheck are more likely to have short coverage gaps, not out of neglect but because money is tight. Under the old system, some of those gaps might have slipped by unnoticed. Under the new system, they're punished immediately. What's especially troubling is how these penalties stack. One violation often sets off a chain reaction. An emissions failure leads to registration problems. A suspended registration triggers insurance complications. Higher premiums make future lapses more likely. This doesn't just punish non-compliance. It can trap drivers in a loop. That's why critics argue these rules are more than safety reforms. They're a new way of enforcing the privilege of driving by using financial pressure as the primary tool. For people already stretched thin, preparation isn't a nice idea. It's the line between staying on the road and being priced off it altogether. As these rules began feeding into state systems, the ripple effects were immediate. DMV offices saw spikes in calls and walk-ins as drivers tried to understand their status. In some places, wait times jumped by nearly 50% in just a few weeks. Insurance carriers, seeing what was coming, quietly adjusted risk scores and announced premium hikes for anyone with recent moving violations. Over the last 3 years, auto shops in major cities have reported a noticeable surge in emissions and diagnostics appointments, many booked months in advance. None of that is random. It's what happens when enforcement, insurance, and compliance all line up. It signals more than routine regulation. It signals design. Federal officials didn't just tweak rules, they aligned every downstream consequence to reinforce them. For drivers, that means one violation rarely stays isolated. It touches your record, your premiums, your registration, and your legal ability to drive. We haven't seen coordinated pressure like this since the early days of seatbelt mandates, when fines and enforcement were used deliberately to force a behavioral shift. Back then, many people resisted until the cost of resistance got too high. The pattern is back, only this time, the tools are more precise and far less forgiving. What this really marks is the end of a mindset many drivers took for granted: casual compliance. The belief that enforcement would be patchy, that some things would slide, that short lapses or small habits wouldn't matter much. After February 2026, that mindset becomes risky. Federal standards now smooth out state-to-state differences. Real-time checks replace occasional ones. Passive monitoring reinforces active policing. Penalties pile up faster than before. The system no longer waits for a big mistake. It catches little ones repeatedly, and small errors, when captured automatically, add up fast. A lot of people still think emissions only matter at the annual test. That insurance only matters if someone asks for your card. That technology can't really see what they're doing in the car. Every one of those beliefs is outdated. The era of casual compliance is ending, not because drivers suddenly got worse, but because enforcement became constant. And when enforcement is constant, preparation is the only real protection. That's not fear-mongering. That's simply recognizing where we are. Driving in the U.S. is entering a new phase, one where accountability is baked into the road itself. Ignoring that shift isn't just risky, it's expensive. The timing makes this especially tough. These rules are landing at a moment when many households are already under financial strain. Cars are expensive, repairs are costly, insurance premiums have climbed. For millions, a vehicle isn't optional. It's how they get to work, care for family, and handle basic life tasks. When new regulations land in the middle of that pressure, they don't feel like safety upgrades. They feel like new threats to already thin budgets. A $400 fine isn't abstract. It's a week of groceries. A $1,000 insurance penalty isn't just a number. It's a month's rent. When those fines stack, when daily penalties start accruing, stress levels spike fast. Transportation agencies can talk about safety and compliance all they want. Drivers experience this as cost. That disconnect matters. When people feel cornered financially, they're more likely to delay repairs, push insurance payments to the edge, or hope issues go unnoticed. Under the old setup, that sometimes worked. Under the new one, it doesn't. The system isn't built to consider hardship. It's built to detect non-compliance, no matter why it happened. That's why consumer advocates are raising alarms now, before February 2026 is in the rearview mirror. They know prevention is far cheaper than penalties, and that awareness is the only real cushion drivers have left. Strip away the formal language from recent federal guidance, and the message is blunt. Compliance is no longer optional, and patience is short. Officials have said directly that ignoring these rules is incompatible with responsible vehicle ownership. In bureaucratic language, that's as close to "this is your warning" as you're going to get. Historically, that tone only shows up when agencies trust their tools and are ready for pushback. And they are. Enforcement budgets are set, tech contracts are signed, databases are live. This isn't a test, it's a posture shift. Billions of dollars in fine revenue are now written into traffic codes nationwide. That money doesn't come from corporations, it comes from drivers. That's what makes this moment different. It's not only about following the law, it's about understanding how hard the law is about to be pushed. For years, people assumed enforcement would stay fragmented, uneven, and deeply human. February 2026 is when that assumption stops being true. The system is coordinated, it's automated, and it's running all the time. The only real choice drivers have left is whether to enter that phase prepared or to learn the hard way through violation notices that arrive without warning and don't go away on their own. In response, consumer groups and transportation attorneys have been unusually direct. They've warned that these 5 rules are calibrated to catch people who wait. Not just reckless drivers, but busy, stressed, distracted drivers who tell themselves, "I'll deal with it later." Later is when the penalties multiply. A missed repair deadline turns into daily fines. A suspended registration creates insurance problems. An insurance lapse leads to a suspended license. Each step removes options and raises the stakes. What's telling is how many professionals are urging people to act before February 2026, not after. They understand that once enforcement is fully active, the systems won't slow down for anyone's learning curve. Grace periods will be short. Appeals will be uphill. Most tickets will be backed by digital records. Attorneys watching early implementation note that enforcement arms are fully staffed, fully funded, and under pressure to show results. Rolling out all 5 rules at once was no accident. It was intentional. When multiple requirements shift at the same time, it overwhelms complacency. It forces fast behavior change. That's the logic behind aggressive compliance drives. And it's exactly what's happening here. Drivers who recognize that strategy have a built-in advantage. They can prepare calmly. Drivers who don't often end up feeling blindsided. The hard truth is that people are not powerless in this, but the window to act is closing. Getting ready now looks very different from reacting later. It means confirming that your insurance has no gaps. It means checking that your car's event data recorder and emission systems are functioning before a violation exposes them. It means understanding how average speed zones and phone detection systems actually work instead of assuming the old tricks still apply. None of those steps are dramatic, but they are protective. They move you from reactive to informed. Informed drivers don't feed enforcement systems with revenue. Unprepared drivers do. That's why this moment matters. February 2026 is not just a date, it's a dividing line. On one side are drivers who adjust early and keep their costs down. On the other are those who keep driving like nothing has changed until the envelopes arrive. What happens next depends almost entirely on awareness. Federal officials are watching compliance rates. Insurers are watching claims and violations. Families are watching their bank accounts. Right now, small decisions determine whether driving stays manageable in the months ahead. Because once enforcement fully kicks in, the system won't ask if you knew. It will only check if you complied. What we're seeing now isn't the end of the story. It's the start of a much tighter enforcement era. Transportation officials have already signaled that February 2026 is Phase 1. As data comes in, priorities will be adjusted, expanded, and refined. Systems that start in big cities will spread outward. Thresholds that seem modest now can be lowered. Penalties that feel steep today can rise later. That's how modern regulation works. It doesn't arrive and freeze. It arrives, watches behavior, and then adapts. That's why officials are so focused on how drivers respond. They want to see whether clear information alone drives compliance, or whether fines become the main teacher. For drivers, that difference is everything. A system that sees strong early compliance tends to stabilize. One that sees widespread non-compliance tends to tighten further. The 30 days before full activation aren't just about avoiding initial fines. They're about shaping what enforcement looks like going forward. Households that get ahead of this ease pressure on the system, households that don't increase it. When pressure rises, so do costs. That's why February 2026 should be viewed as a turning point, not a routine update. It marks the moment when driving in America becomes inseparable from constant verification. Technology enables accountability. Accountability enables enforcement. And automated enforcement creates financial consequences quickly and consistently. Drivers who take the time now to verify they're in compliance are likely to remember this as a close call they successfully navigated. Drivers who shrug it off may remember it as the month driving suddenly got a lot more expensive. The difference isn't luck, it's awareness. The rules are already written. The systems are already running. The penalties are already set. What's still undecided is how ready drivers will be when enforcement speed increases. Because once February 2026 hits, there will be no doubt about what changed. Only the question of whether you adapted in time or whether your first introduction to these rules arrives in the form of a fine. Preparation is what separates those who stay in control from those who pay. And right now, preparation is still an option.